Every lawyer and every law student in this room knows Brady versus Maryland. That's, of course, the 1963 United States Supreme Court case, which held that it is the duty of the prosecutor to disclose to a criminal defendant all of the exculpatory evidence which is in the government's possession. It's the linchpin of our criminal justice system, the guarantor that its essential theme be fair play, not a contest for a guilty or a not guilty verdict. Peter Eliasberg and Esther Lim of our office discovered evidence that the prior district attorney's administration had instituted, had designed, had implemented procedures to subvert Brady, to eviscerate its meaning, to deny criminal defendants exculpatory evidence. Exculpatory evidence like the fact that there were sheriff's deputies accused of beating inmates at Men's Central Jail who thereafter were involved in filing criminal prosecutions against those same inmates shortly after the beatings, and that those deputies were in fact the subject of ongoing criminal or administrative investigations. The district attorney's office, the prior district attorney's office, withheld that information from those defendants, that those same deputies had been the subject of criminal and administrative investigations for similar sorts of brutality. The district attorney's office previously had also rewritten the rules of Brady, rewritten the rules so that instead of all exculpatory evidence being disclosed, only that so-called evidence which the district attorney concluded by a clear and convincing standard, which was nowhere in any of the cases, would result in a different outcome of a criminal trial when that trial had not even begun, when the defense was not even known, that no information that did not meet that test, no matter how otherwise exculpatory, would be disclosed to the defense. When we learned of this information, the very first call that we made was to the Byrd Morella Law Firm. And we talked to them about this worst scandal in the history of the country with respect to the systemic withholding of Brady material. We called them and we teamed up with Ben Gluck and Ben Lichtman. And we did so not just because of their well-known intellectual firepower. We did so because the reputation of that firm, and these lawyers in particular, were as attorneys for the damned, who in the spirit of Brady were known for their meticulous and persistent insistence upon the integrity of the criminal justice system. We at the ACLU working on this case saw those strengths in their preparation, their prosecution, and ultimately their settlement, the settlement of this terribly important novel civil rights suit filed in September of last year. The anti-Brady bunch in the DA's office is now history. It is history because of the work of these lawyers teaming up with the ACLU and because of the courageous commitment of a new district attorney. This is warp speed by litigation standards, and it has already resulted in the reversal of countless guilty pleas and countless guilty verdicts that had been obtained through withholding evidence of perjury and, frankly, thuggery on the part of many deputy sheriffs. As a community, we are indebted to this law firm and to these lawyers, Ben Lichtman and Ben Gluck, this year's winners of the criminal justice system, this year's winners in restoring that justice system to the intent and the plan established over 50 years ago in the Brady case. The winners of the Criminal Justice Award, Ben Lichtman and Ben Gluck.
I was instructed to be brief. I really feel like we should be thanking the ACLU for the opportunity to work with them and such phenomenal lawyers on such an important case. So I should start off by thanking Mark and David Sapp and Peter Eliasberg and the other people that we were able to work with. I'd also like to thank Ben Lichtman of the Bird Morella firm, as well as all my colleagues at Bird Morella who have never shied away from tough cases, even tough cases that are pro bono. And this one ended quickly, but that was never a consideration when it came to thinking about whether we should put our resources behind it. The only other thing I'd like to point out is that the problems that Mark was talking about are an indicator of systemic problems in the criminal justice system, in the state criminal justice system here in Los Angeles County. And sometimes we think that something that blatant and that wrong can't exist. But there are problems that are that blatant and that wrong and that widespread. There are big problems out there. And the second point is that the ACLU is not afraid to take on those types of big problems and solve them in the way that we were able to do here at lightning speed. And so again, thank you for the opportunity to work with you, and we look forward to working with you on the next one.